Well, people are right now. Good morning, everyone, and welcome to the first of what we hope will be many construction law forums here at Mandelbaum Barrett. My name is Jackie Vogt, and I am the chair of our construction law group.
And my name is Boris Peyzner. I am a litigator here, and I also handle a lot of construction litigation.
So we wanted to get together today. We want this to be, we're going to be making a presentation to you about 10 steps for planning a successful construction project, but we don't really love being talking heads. You know, we don't want to preach or just talk at you. We want to turn this into a conversation. We like a give and take. Anyone who's attending virtually, please don't hesitate to unmute yourself at any time and ask a question, or if you want to make a comment or add to the remarks that we're talking about, that's a very, very welcome thing. This is a forum, an exchange of ideas, sharing of experience. Our goal is to help you and help you help the people you help to have successful construction projects. Now, what does that mean? A successful construction project, by definition, is number one, on time. Number two, within budget. Number three, free from defects. I think everyone would agree that that is the definition of a successful project. How do you get there, and why is it so important to talk about these things before getting involved in a project? Let me make a caveat here. In this room and virtually, we have construction industry people from lots of different walks of life. We have contractors, we have construction accounting people, we have litigators. I personally do both construction contracting and disputes. And online, I know we have contractors and other industry professionals, designers. You know, we here at Mandelbaum Barrett represent across the board. There are some law firms that stick to, you know, contractor side or owner side, but here at Mandelbaum Barrett, we handle both sides. We represent owners, developers, designers, contractors, subcontractors, and we handle everything from the initial contract negotiations and drafting through project administration. We as lawyers can help a project be successful by being available throughout the construction process to help make sure that little problems that come up during this process don't turn into big problems, because big problems mean delays, claims, terminations. And as I said, that's really the definition. That's exactly the opposite of what we want here. We want everything to go smoothly, start to finish. All project participants benefit from achieving a successful construction project. According to a McKinsey report, most projects across all asset classes typically take 20% longer to finish than scheduled and are up to 80% over budget. So this is a far-reaching problem in the construction industry. Right now, construction industry is on an uptick, and the pundits say that construction is going to continue through 2026 to continue to be on an uptick. The kinds of construction projects that are very hot right now are multifamily, mixed use, which is sort of eat, work, play, and industrial. Those are the three types of projects that are hot. In terms of the strategies that we want to talk about today for ensuring that your project is successful, where do we start?
We have to start with the contract. Everything starts with the contract. That's the most important document that you have in any kind of construction project. When you do start a construction project, the most amount of time has to be spent on carefully drafting the contract, negotiating terms of the contract, Because if there's any kind of issue, the first question any lawyer is going to say to you is, what does the contract say?
So as Boris said, the contract is the document that defines the roles of the parties, allocates the risk, and sets up from the beginning the expectations and obligations of all parties. Now, if you're on the owner side, Aaron, can you advance the slide? So an owner drafted contract is going to allocate the majority of the risk from the contractor. I'm negotiating one of these right now, $50 million multifamily project here in New Jersey. And this owner is dealing with funding from a very, very risk adverse lender. So the lender is demanding that the owner's contract with the contractor shift literally all of the risk onto the contractor. My job in negotiating this contract is to try to allocate that risk a little more evenly. Now, why do I want to, to me, a fairly allocated contract is the one that's more likely to be successful. Really, what should happen in a well-negotiated construction contract in terms of risk allocation, the party that has direct control over that portion of the construction that creates the risk, it's fair and appropriate for that party to bear the risk of that item over which they have control. When no party has control, then the party who's best able to protect against the risk should be allocated that risk. And when no party has control at all, the risk should be allocated to the owner, because the owner is in the best position to shoulder the burden of that risk, and also is the ultimate beneficiary of the project and of the results. So it's only fair that the owner bear that risk. In the situation that I mentioned, where the owner is seeking to allocate all of the risk onto the contractor, well, what does that result in? Why is this a bad thing? Because then the contractor has no choice really, except for to build in lots and lots of contingency. And I mean contingency beyond just the line item for contingency, but for example, the one that I'm talking about that I'm negotiating right now, there's a $3 million general conditions line item in the contract. But because as we're negotiating, the lender is being so adamant about allocating the risk to the contractor is saying, you know what, I'm going to have to increase my general conditions up to $4 million. And the contractor is going to look to buttress all of its schedules of values a little bit higher to compensate for the fact that it has to anticipate it's responsible for everything.
Contracts really need to be fair to both sides. If you push too much responsibilities on one side versus the other, it just creates a situation where you almost will have a dispute at some point, and a dispute doesn't allow the project to get completed. Number one goal is to have the project completed. Purpose of the contract is to make sure that parties' expectations are set ahead of time and everybody knows what everybody's responsible to do.
So how does one make the contract carefully crafted? Well, you have to make sure that decision makers on both sides are identified, and those people have to be available. The work has to be described in detail. There have to be detailed descriptions of the controlling drawings. There have to be detailed specifications, identification of materials, and there have to be specifications as to how the work is going to be done. The insurance requirements have to be outlined in the contract. And the starting date and the finish date have to be clear. We've already talked about a fair allocation of risk. One of the biggest risks on a construction project are construction liens. And a careful contract has elements in it that protects both the owner and the contractor against liens. From the owner's perspective, an owner can protect itself against liens by making the payment provisions of the contract, the payment provisions of the contract include very clear provisions on how a contractor gets paid. So I imagine most of you are familiar with the G703 AIA form of payment application. And in the payment application, the owner should require lien waivers, partial lien waivers, and partial lien waivers for work that is expected to be completed and expected to be paid downstream to subs and suppliers, and final lien waivers with respect to work completed that's part of the payment application. If the owner makes payment contingent upon the contractor supplying those lien waivers, that's a very powerful tool to making sure that no liens get on the project. If the contractor cannot supply a lien waiver, then the owner is well within its rights to withhold payment for any portion of the payment application that doesn't include a lien waiver. From the contractor side, this is also a tool that the contractor can use with their subcontractors. The subcontracts would say, hey, you subcontractors are bound by the same terms to me, the GC, as I am bound to the owner. And if the subcontract contains that very important language, which by the way requires the GC to provide the subcontractors with a copy, Todd's looking at me, he knows what I'm talking about, to provide the subcontractor with a copy of the general construction contract, and then the onus is on them, and they have no basis to complain about non-payment or withheld payments or payment applications, portions of them not being certified or held, because the contract is crystal clear that in order to be paid, these things are required. And as I said, this is the key to preventing construction liens. And construction liens are a problem on every level of a construction project. The subcontractor is in the position of filing a lien because they haven't been paid. But lien rights only exist as to subcontractors. Two levels down. So subcontractors and subcontractors have lien rights in New Jersey anyway. But once you get down to the sub level, there are no lien rights. They don't exist. So the subcontractor would much rather get paid than file a lien. Filing of a lien disrupts the project, creates sort of this adversarial relationship, which is antithetical to what we're trying to accomplish here. What we're trying to accomplish with careful contracting is right. We want to be cooperative. By its nature, a construction contract, there's an adversarial bent to it, but it is to the benefit of all project participants for there to be a spirit of cooperation. Think about it. Everyone has the same goal. Everybody wants a successful project, and everyone wants to work cooperatively to get there.
And the filing of liens could also be a breach of the loan agreements on the project itself. So again, going back to the careful contracting on the construction contract in the first instance, to avoid the filing of liens is very critical.
Not only is it typically a breach of the lending agreement for there to be a lien, but same thing, all levels down. On if the contractor is a bonded contractor, having a lien filed is a potential claim against the bond. A claim against bond is a default with respect to the contractor's credit ability to draw. And all of these things, you can, as we're talking about it, I think you can see how everything trickles down. So it is incumbent on all project participants to try to avoid this as much as possible. Also, by including this language that we're talking about in the construction contract that says lien waivers are a prerequisite to payment, you also impact the ability of a sub to file a lien. Because if the contract says you're not entitled to payment unless you provide lien waivers, then you don't have the right to file a lien for non-payment. Another construction contract term that can help avoid liens is a pay when paid provision in the contract. I could go on forever about construction contracts. Maybe that's going to be the topic of our next construction law forum. But if you include a pay when paid provision, meaning that the general contractor is not required to pay the sub until the general contractor receives payment from the owner, again, that shortcuts lien rights from the subs. They can't tie you up as a general contractor with liens or as an owner because the contract does not entitle them to payment. Liquidated damages provisions are important. Boris, do you want to talk a little bit about liquidated damages?
Sure. Liquidated damages is typically when parties can't necessarily estimate what the damages would be if there's some kind of, for example, delay in a project. They could put in a provision into the contract that says that for every day that you're delayed, there's X amount of dollars that's gonna be reduced from the project because perhaps there's a need to get the project done by a specific period of time for a specific reason. So the parties try to estimate what that damages would be ahead of time, negotiate onto those terms, and then everybody knows what the expectations are if there's some kind of project delay of what the damages would be. Because it's in the contract itself.
It sounds liquidated damages can sound kind of punitive.
Penalty.
They are specifically not intended to be a penalty. They're supposed to just compensate for the difficult to calculate actual damage that an owner would suffer if a project was not completed on time.
And agreed upon ahead of time so that parties' expectations are there. They know what it would be if there is a delay. It's not going to be a surprise to either party.
Right. Look, contractors hate liquidated damages, but lenders often require them and owners often require them because of the time cost of money. That's not to say that a contract substantial completion date can't be extended as a result of things that come up during the project, but liquidated damages are intended to, to cap out, like, there could be a per diem liquidated damage. There can be a cap on liquidated damages, for every day that you're late, $1,000 up to a cap of X dollars. And a way to sort of offset the punitive feeling of liquidated damages. Sometimes you might want to put an early completion bonus for the contractor. And that way there's incentive on both sides to get the project done.
But it's important that liquidated damages is a reasonable assessment of the damages that would be sustained. You can't just take a number out of thin air and say, it's going to be $1 million or it's going to be $10,000 a day. It has to be some kind of expectation of the losses that would be sustained if there's some kind of issue with the project.
One situation that I had a number of years ago, it was a school project. They were building a school and, there's very clear requirements there. They had to get the project done by August because they needed to outfit the school and get the kids in the building by September. So that's a very clear need to have a liquidated damages clause to encourage timely completion. A careful contract is also going to we've touched on this already. is also going to contain very, very clear payment terms. In order to get paid, you have to provide the payment application. You must provide all subcontractor backup. You must withhold 10% retainage from every application until the end of the project. You must provide, you must have the architect or whoever's in charge of reviewing the progress of the work confirm that the payment application accurately represents the percent completion of the job.
And those payment terms should be structured in a way that's fair to both sides. So I had a case once where the way the payment terms were structured, they were heavily slanted in favor of the contractor. So most of the payments were made early on in the project. And as a result, the contractor had less incentive to finish the project quickly, started taking the men off his one project, putting it on another project, really delayed the project for the owner. And the owner didn't have a lot of ability to incentivize the contractor to come back because he paid most of the money already during milestone payments that were called for in the contract early on in the project. So structuring payment terms with appropriate milestone payments is very important.
And a careful contract should also include very clear definitions of substantial completion and final completion, because these are defined terms in the contract that trigger payments, trigger ability to get a TCO and a CO. And last but not least, in the contract, we really need to lay out a dispute resolution clause that works. I'm personally in favor of a multi-level dispute resolution where you try to work things out first before heading into mediation, and then as a last resort litigation or arbitration. So we're going to move on now to our next strategy for successful construction project, which is obtaining independent cost estimates, unless there's any questions on what we've been talking about so far. Okay, so what's an independent cost estimate? You have a design.
Sorry, I was on mute. Is there, I just have Joey Porchetta. Good morning, everybody. I am a new contractor. We're subcontractors. We're also owner's side. So this question is directed specifically just to a subcontractor. And more so, I just want to make sure that I have this clear because, a 40-person company trying to go after a Skanska or a Bell Contracting or a big guy, right? We're not going to touch their contracts. I just want to make sure that I got this right. You're basically saying go after scope, go after time of completion, and go after spec. That's kind of what I gathered in that.
In terms of what you think you can negotiate contracts.
Correct. Yeah. Because we can't touch the physical contract itself. Like if we ever try to do that, they kind of say, hey, that's not what we do here. And we can try to pin that a little bit. If we're really firm on it, we'll walk away really. But we sign paid when paid contracts. There's no way we're getting around that. My stance really, I agree with, and I wrote it down specifically, is to just go after scope, timeline, and spec.
And in terms of your schedule of values, if the owner or the GC is one of these big players that isn't willing to negotiate a whole lot, my advice is, take a good look at your contingency and make sure. And also you want to, some construction contracts, the contingency give owners some ability to use the contingency. You want to make sure your contingency clause is contractor only. Okay. Subject to approval by the architect, of course, but you don't want to allow the owner to be able to use the contingency for change orders.
Go against it, you're saying. Okay. Yeah. Understood.
Sure. Yeah.
Thank you.
Absolutely. So what's in
Jackie? Yeah. I'll chime in for a second.
Okay.
What's up, Joey?
How's it going, Todd?
To Joey's point, and again, if any of this isn't pertinent, just shut it down. Obviously, we can talk one of the 17 times we talk per week. But, you know, I think, and you hit on it before, there's three people, three entities involved in every contract. It's the owner, the general contractor, and then all of the subcontractors. And they're in no way aligned when it comes to a contract. The owner wants to put all liability on the general contractor, and the contractor grabs a hot potato and wants to pass it on down the line. And, you know, unfortunately, the subcontractors are generally the ones left holding the hot potato at the end of the day. And to Joey's point is a lot of these big contractors will say, either sign it or the next guy in line, he's up at bat. And it's unfortunate, but I've learned to just walk away.
I'm glad you said that, Todd, because that's exactly where we were headed with this. If you are uncomfortable, just don't do it.
Yep.
You know, and that's something that comes up a lot, especially in terms of bidding. If you are bidding on a project and you put in your bid and it gets rejected, or they ask for corrections for one reason or another, and the change that they want you to make makes you uncomfortable or makes you wonder whether you can really do this job successfully or profitably, then, you know, just go up and walk, you know.
I think the catch-22, and again, in our industry as subcontractor owners, is if you push back too hard on every project, you're going to get nowhere. Because there's always some dummy standing behind you that's ready to sign anything that they put in front of them. And now you're deciding between, do we not do any work and take a shot at these contracts, and it's only a problem if something goes wrong? Or do we stick to our guns and kind of hope that we get enough work to cover our overhead and maybe make a couple of bucks? So there's no, like, it's a lose-lose when you're a subcontractor.
And listen, the construction industry is notorious for the low margins. I mean, we're not talking about, you know, like a liquor store or a restaurant that's selling alcohol at a 300% markup. You know, your markup in the construction industry is really small. So these are legal issues that drive business decisions, in my view. You know, if you think that risk, if you look at the project and you see that this is a very owner-sided contract, the one I'm negotiating right now, the general contractor has been involved since day one. They're heavily invested in the community. They've done projects there before. So it's a very owner one-sided contract, and that's what the lender is insisting on. But the contractor says, I'm doing it anyway because I know my subs, I know the project, I know the town, and I have a lot of confidence based on my experience that I can do this on time within budget. So I'm willing to take that risk. So that's a risk benefit analysis, really.
It's always a business decision, right? It's a calculus to determine, can you do the project, or are you going to sign a contract and set yourself up for litigation? Because you don't want to buy litigation. That's the last thing you want to do.
I think that there's certain things that are just not negotiables in it. You know, cost escalations. You don't know what's going to happen in the world. Again, COVID hit, the cost of lumber went up 800%.
So since COVID, we construction lawyers have changed the way we've approached cost escalation in contracts. Prior to COVID, cost escalation was on the contractor. I litigated a case where the contract was entered into pre-COVID. This was a pretty sophisticated owner developer GC, played all three roles. Okay. There were and this was not a contract that I drafted or negotiated. They put in very clear terms that said, you subcontractor are required to get your suppliers under contract as soon as you sign this subcontract. And that is an obligation on you. That was a risk allocation mechanism. So including lumber. Okay. Now this contractor framing, not you, did represented to the GC owner that, yes, we have all our subs and suppliers under contract. But they didn't. So then COVID came, and as you said, the cost of lumber went up 800%, and the contractor comes, the framer comes back to the owner and says, cost escalation, COVID induced, I need, I need to increase my lumber budget by 200%. Here's a change order. What did owner say? That's on you, buddy. You were required to get those suppliers under contract when you signed. You didn't sign. That cost escalation is on you. So that's a pre-COVID situation, but of course it resulted in litigation because the contractor couldn't afford it and the owner was insisting on it. So it was a matter of who can bear this risk. Post-COVID, what we do now, construction lawyers, is we include language that says, in the event of a cost escalation beyond 20%, we are entitled to a change order,
And that's the negotiation is the percentage that you agree to.
Yes.
Okay.
That's exactly.
Yep.
Yeah.
And, and of course, force majeure as well.
Yeah.
Does everyone know what force majeure is? It's a clause in the contract that says if some event occurs over which no one has control, whether it be an act of God, a hurricane, or a pandemic, then the contract time and money shall be equitably adjusted. And the key language there is equitably.
Do you have like a sample clause, that force majeure,
Yeah.
and also the cost escalation that maybe you could do like a generic and send it out to everybody that's on the call? And
I do. I believe that also the AIA forms also have some of this generic language because it's really been prevalent across the construction industry since, every contract, I modify every AIA form.
most people don't. They just take one that's been in their system forever. So if you have that, and
Absolutely.
and then anyone who's not on the call doesn't count.
Absolutely.
Can you share that through the group?
We have emails, right, Aaron? Absolutely.
Just a question. A lot of issues we see with clients is around their retainage, particularly as subcontractors. Can you maybe just speak for a minute or two just about, or briefly, just how can they define the terms of retained release? I think you touched on substantial completion. I assume that might be a big component of when retainage may get released from, let's say, a 10 to 5, or
Right.
Is that something that you see standard? I mean, how do you typically approach retainage?
So it's all over the place. Industry standard is 10% retainage from every application, and then until substantial completion. I have seen and I see frequently that that contractors, of course, want retainage reduced from 10 to 5 when the project's at 50%. From an owner's perspective, I would never agree to that.
Mhm.
From a contractor's perspective, it makes perfect sense. And then retainage at substantial completion, and substantial completion has to be very, very clearly defined in the contract. I litigated a case, it was, a never ending litigation where the definition of substantial completion was, the date on which the project was, the owner was able to use the project for its intended use. That's the typical definition of substantial completion. In this contract, it said substantial completion is defined as the receipt of a C of O, okay, which is a very, very different requirement. So it's that same school project I was telling you about before. The school district got into the school, was using the school, but they never got a C of O. They only had a TCO, and they kept renewing the TCO. And liquidated damages continued to accrue while they were using the building. So that was the issue being litigated, is that fair and equitable? And maybe it is, maybe it isn't, but the contract said substantial completion is defined as C of O. So again, careful contract. I think we need to do a whole second session on construction contracts. I could talk about construction contracts forever.
But that just shows how important they are.
Yeah.
I mean, again, I said it before, everything always goes back to the construction contract because that's what the parties agree upon. That's what sets the parties' expectations. And that's what us lawyers look at to determine everybody's responsibilities on the project.
So I'm gonna, unless anyone has anything else, I'm gonna move to step 2. I don't know if we're gonna get through all 10 steps today. We'll have to
May
go
have
back.
to do volume 2.
Right, exactly.
Yeah.
So let's talk about independent cost estimates. Why are these important? So an owner is taking bids on a project, and the contractor comes in with a bid, and let's say the owner gets 3 bids, and they're all, reasonably close to each other that it makes sense. You're gonna select, the bid that makes the most sense to you. I want to stop here for 1 second and comment on something with bids, to follow up on something that Todd said. And you don't choose the lowest bid. What you do is you choose the lowest bid from the most responsible bidder. So if some inexperienced, no credentialed contractor or subcontractor comes in with some lowball bid to try to get the work, and contractors do this all the time, they'll bid low and anticipate making up that difference in change orders. Happens all the time, something to be very conscious of when you're looking at bids. If it's really so low, be suspicious, look at it. And one of the ways you can look at it is by doing an independent cost estimate. We all know a lot about construction. We all do this all the time. Regardless, bringing in a third-party independent estimator can result in 2 things. Number 1, showing you if your bids are accurate, meaning that the bidder will be able to do the work for the price without, the need for excessive change orders. Number 1, and number 2, make sure that the work and or the materials that are part of the bid are actually available for that price. Again, I like to talk in terms of war stories because it helps me. I'm an anecdotal learner, and so I remember things when I have a story to go with it. So in this situation, a case that I litigated, the contractor came in with a unit price for a particular narrow scope of work. The unit price for that scope of work, it was terracotta spall repair. This was a masonry restoration project on a 150-year-old brick building with all kinds of terracotta elements. And the terracotta spall repair, as distinguished from crack repair, came in at $2.05 a square inch. Other bidders came in at $3.50 a square inch, $1.80 a square inch, and one bidder came in at $285 a square inch. So, the architect who was managing the bidding process goes back to the contractor and says, what is this? This doesn't make sense in view of everything else I'm seeing on these bids. And the contractor says, oops, I bid it in square feet by accident. And the architect said, okay, please revise your bid, give it back to me in square inches, and we'll go from there. So the contractor does that, and based on the revised bid, is awarded the contract. Then, this is again, importance of careful contracting. The contractor put together the final execution copy of the contract, attached the bid that said $285 a square inch to the execution copy, and sent it in. Nobody noticed. So, shame on the architect. Nobody noticed. The project progressed for 2 years, and there was a significant amount of unit price work for this terracotta spall repair. So everyone goes back to the contract and says, okay, we need to pay you now. And we're going to go with the $2.05 a square inch that was in your revised bid. And the contractor says, wrong. Here's the signed contract. It says $285 a square inch. I'd like a $14 million change order, please. Okay. So number 1, careful contracting. Number 2, we ended up trying this case over whether $2.05 was a reasonable price for this work. Now, the owner said, it's in your bid, so I'm going to assume it's reasonable. And the trial judge said, I want to hear expert testimony as to what the reasonable value of this is. had we done independent cost estimating for that unit pricing, we wouldn't have been in this situation. So 2 lessons there. Number 1, look at the contract. Number 2, an independent cost estimate for this. The bids were, like I said, 180, 205, 350, 285. Bing, 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 warning signs should go off. Let's take a look and see what is a realistic price for this type of work. Anybody have questions? Bill, you look like you have a question.
I'm just curious who won that case.
I'll let you know when
$14 million check.
yeah.
Yeah, probably right.
We tried the case in February, bench trial. We're waiting for the judge's.
Oh, so that's a very recent case.
Very,
Wow,
very,
very
very, very recent case. It's so funny that you say that because the last time I spoke and I mentioned that was everyone's question. I spoke at the State Bar Convention on ethics in construction contract negotiations, and this came up because, is that ethical?
There still is good faith and fair dealing, and it seems like that is the complete opposite of good faith and fair dealing, but.
Yeah, when I cross-examined the contractor who did this, I got him to admit on cross that his office assembled the execution copy, that he knew that the bid was awarded based on the revised bid submission. And then the judge cut me off and said, "Oh, come on. What are you suggesting, that he slipped it in as a trick?" And I looked at her and smiled and I said, "Thank you, Your Honor, I'll move on." But that's exactly what I was suggesting. And I hope that she would have bit my head off if I said, "Yes, Your Honor," but I think I made my
Jury trial or bench trial?
bench trial in New York, of all places.
Oh.
So moral of the story, read your contracts before you sign them.
Yeah, take one last look. Yikes.
Any questions on independent cost estimating? Aaron, can we go to the next slide? So establishing a firm budget. Well, I almost feel like this goes without saying. In order to reduce the risk of overruns, you have to have a clear budget. The designers have to design the project within your budget. And this happens all the time that designers don't. That an owner will go to an architect and say, I would like to build this building, and my budget, just for the sake of discussion, my budget is $5 million, but I want really, really high-end millwork and finish work. I want this to be really, really nice. And the architects, they're artists, they're designers, and they come back with this design that meets every one of the owner's requirements. And then it goes out to bid. The contractors come back at $7 million. That's a problem. You've just wasted a lot of time and money on a design plan that you can't build. So this dovetails into step 5 in our strategies. Aaron, can we, so step 5 is peer review of the design. Next one. Peer review of the design. Had the owner required a peer review of the design, they wouldn't have been in that position. Another thing that peer review in the design can prevent is, poor coordination and sequencing. It can also prevent, move to the next slide, 6, constructability. And Boris, you had a situation with an issue.
It was a high-end new construction home that was designed by the architect beautifully. Except what they didn't account for was the fact that when the fireplace was going to get framed out going up, it was going to reduce the space inside some of the bedrooms, not the master bedroom, but some of the ancillary bedrooms. And that was never really looked at until it was framed out, and you walk into the room and you're like, where's the framing going for the exhaust? And as a result, the owner had to spend a lot of money to redesign the fireplace to essentially pull the smoke down and out of the building instead of allowing it to go up. and it just added to additional costs to the projects and ate away at the profits of that project.
And delay.
Yeah,
And the delay. So, so you need in establishing your budget, you need to know that the project can be built for that budget. You need to know that the design meets the owner's expectations for both vision and money. And you need the contractor to be able to build it the way that the designer envisions it. So again, I think this emphasizes that there's a very cooperative process, that the players, everybody has to work together. And you really want to establish very, very clear lines of communication. You want to identify who the decision makers are, and you want to get those people into a room to hash things out before a small problem turns into a big problem. One of the things, I'm kind of jumping around here just because this is the way the conversation is flowing. I hope everyone's okay with that. Erin, can we go back to step 4, using add and delete alternatives? So going back to Boris's example, when the owner has a really clear and immovable budget, the lender's only going to lend this much money, but there's a lot of stuff the owner wants. And a way to handle that is called an add or delete alternative. And that gives you a baseline project with a baseline budget. And then depending how the project goes, depending whether you can do some cost savings here or time savings there, it's sort of like at a Chinese restaurant, where you can, pick one from column A and one from column B, where you get to a certain point in the project, and using Boris's example, perhaps they want a very high-end fireplace, but are not sure if once all the framing and once all the electric and plumbing is in the walls, whether it's going to fit or just be too expensive. You can make that an alternative. So that, when you get to that point in the construction, there's an opportunity for the owner to pick and choose. Okay, option 1 is a smaller fireplace. We don't have to worry about this spacing issue with the chimney. Option 2, it's going to cost a little more, but you're going to end up with a bigger, nicer fireplace. And the owner then can make that decision. That shows this cooperative approach, and it shows clear communication. And there's going to be a lot more goodwill between the parties, because nobody's trying to trick anyone. Nobody's trying to upcharge anyone. It feels like you're working together to consider the options and pick the best option for this project.
And sometimes a complaint that you hear from owners is whether the contractor is giving you a price at some point later on in the project, because they don't want to do the work unless you pay them some kind of, insane amount of money to do that work, because they're running behind. They need to get their guys off this job, move them to the next job. But if you agree on those terms ahead of time and have that as an option in the contract, that helps avoid any kind of bad blood between the owner and the contractor. And again, it goes back to setting the parties' expectations, which is always in my opinion, the most important thing.
I'd like to move on now to
I just have one question. You for as the owner, you said under budgets, input peer review for design and budget. Do you guys have any firms that do so? Just out of first sight, we're using Minnow and Wasco for one of our buildings, big building, right? We have a construction development team that's doing everything. Not to say I don't trust them, but who do we use to do a third party peer review on design and budget? Or is it 2 parties? Is there anybody that you guys could share with us to do that?
You would want to use a sort of peer designer. And yeah, there's plenty of them out there that will do this. And, after this meeting, I can certainly email you some recommendations if you tell me a little bit about the project. So
For sure.
I can, and in terms of the cost estimating, there's a lot of, again, independent cost estimating is a whole it's a whole industry in and of itself. So there are professional construction cost estimators. That's all they do. Now, the big firms, the big consulting firms that's where you can get all of this done under one roof.
Okay.
Hill International is one, some of the biggies, if you're looking for one-stop shopping.
Would love to know those.
Okay. All right. Let's follow up after today. Tell me
Yeah.
a little bit about the project and then we can go for there. Let's go to step 7. This is another one that I can talk about for a while. So setting a reasonable schedule for the construction. Can't emphasize enough that on both sides of a project, the requirement of reasonableness. And Todd, this kind of dovetails back to something you said before. If this schedule is so tight that you really have concerns about whether the project is buildable within that schedule, best thing to do is walk. If they won't negotiate it, walk away. I think everyone understands the importance of keeping to the schedule. All construction contracts have to necessarily account for the fact that there are going to be things that come up during the course of construction that will require changes, and everyone will have a changes clause, but you can't count on it. You can't count on the lender being willing to extend, and you can't count on the owner being willing to extend. And going back to the school example, that's something set in stone. They have to get into that building for the start of the school year, or else where are they going to put those kids? It just can't be moved. So if you're looking at the work that's required to get to that substantial completion date and you think that it's too tight, that's a problem waiting to happen. And you have to consider that, and maybe you want to do it anyway, but then you have to up your cost, because you're going to end up paying acceleration costs to get work done more quickly. The other thing that happens when the schedule is unreasonable is contractors will start cutting corners. And this happens all the time. And if a reputable, good quality contractor is put under unreasonable time pressure, they really almost have no choice, because they face the threat of the penalties for late completion, whether it be liquidated damages or something else. So you really need to make sure that the schedule is reasonable.
I think a big one for that is what's reasonable and what's not reasonable. 3 feet of snow, I don't care, you sign the thing, that's not my problem that you're delayed.
Yeah.
That is unreasonable.
Well,
You said you had 20 guys that you were gonna put on the job every day, and I see 4, that's the subs problem.
so again, going back to construction contracting, weather delays are typically addressed. In order for a contractor to be able to get a time extension due to weather, the contractor needs to show that the weather is unreasonably different than typical. So that requires a contractor to get weather reporting from these weather sources to show that in every year, the temperatures are typically 50 degrees. So I could have done it, but this year temperatures were 30 degrees. We had 3, and this hasn't happened in 20 years. And then that will support a change order for a time extension in that circumstance. But if it's just sort of, a big snowstorm and we lost 2 days, well, I'm going to have to make it up somewhere else. Which is why you need float in every sequence, every part of your sequence, and use the float wisely. So, the things that the owner might do that would impact the schedule is not providing the permits on time, having land use issues, there on both sides, there are things that you can do. You can not even go out to bid or start your project until you have your permits in place, or at least your approvals. Let me give you again, an anecdote where a delay like that, a weather delay, caused a problem. So I litigated a construction of a commercial building. It was a supermarket, and it was in Chicago. So the limited real estate. So the design of the building called for the parking deck to be sort of on top of the grocery store. And it's a Chicago winter. And that's to be expected, right? So the contractor should have planned its work. But because of delays or whatever reason, contractor ends up pouring the concrete on wet, cold days that were not, maybe not completely atypical, but they were colder than they should have been for the concrete to set properly. Contractor did it anyway because they were under pressure to get the work done. Lo and behold, the building opens up and they start parking cars on it, and the concrete parking deck is cracking and spalling everywhere. Had the contractor scheduled and sequenced its work to make sure that it was ready to pour concrete before the weather turned bad, but he didn't, and that didn't happen. And so now here we were post completion with the contractor being sued to replace the entire parking deck because of the issues with the concrete. So the schedule. Now there's a lot of different types of schedules that projects can use. You can use CPM schedules, that's critical path method schedules. These kinds of schedules are digitally based. I have a client right now, a general contractor who's never done digital CPM schedules before, but this contractor is doing a big project for an institutional client who is insisting on CPM scheduling. CPM scheduling is a great tool, but this contractor has never used it before. So my advice to him is, are you comfortable doing this? Do you want to do this job? It's going to require something outside of your comfort zone. He wants to do the job very badly. So my recommendation is to bring in a consultant to do scheduling. There's a consultant out there for everything you need. So this contractor has to bring in this consultant. There's going to be a cost associated with that. He's going to have to up his general conditions. These are all the things that you need to think about when going into a project. There are Gantt charts. It's another type of schedule, a little bit less sophisticated, a little bit easier and less expensive. Can do that more in-house. And you want another way to really stay on top of your schedule is to do three-week look-aheads to make sure you're constantly reviewing and evaluating and coordinating the work to make sure, if you've got the electricians are done or finishing up over here, but you didn't schedule the plumbers to start until next week. Well, you could maybe want to start the plumbers, where the electricians have already finished and get things going. And that will assist you with, it's always best to not only stay on schedule, but if you can save yourself some time somewhere, because you might need it later. Let's talk about, are there any questions on scheduling?
I think just from a subcontracting, I know I keep going back to that because that's where I spend my days, is, you want to make sure that you or I am not being punished for the 3 trades ahead of me for being behind schedule, because that happens quite a bit, where all of a sudden my timeline changes because someone else took longer than they were supposed to. And again, it just becomes adversarial. It becomes threats. It becomes, we're going to back charge you. It's unfortunate. So you got to make sure in the contract you have specific language that says, unless it's 100% my fault, not 80%, 100% my fault, I cannot be penalized for taking a little bit longer than I was supposed to be.
And I think what you're talking about, Todd, really illustrates the importance of construction project management, which is another topic we could spend a whole day talking about. A construction project manager is watching things like that very, very closely on behalf of, really on behalf of both sides, the owner and the contractors, to make sure that that kind of thing doesn't happen, or if it does, there's sufficient float in the contract to allow for it so that you can still stay on schedule. And you as a sub, when you're bidding the job, you want to look at that schedule and make sure that there's, if your work is going to take 180 days, you want to make sure there's 200 days in that schedule. We're going to move on now to step 8 for a successful construction project. Submittals. We've, I think, touched on quite a bit during this discussion the importance of communication between owner, designer, contractor, sub. The more communication there is, the more likely your chances of success are. The subs who are actually doing the work need to submit shop drawings to the design team to make sure that the way the shop drawings reflect the work is going to be done works from a design perspective and answers any questions that the contractor has about the work. We have an example of, I think the chimney example that Boris talked about is a little bit illustrative of this point, but the shop drawings take the construction design drawings and break them down to the core detail. Every electrical outlet, every plumbing line, everything is going to be depicted on the shop drawing. And the designer reviews those shop drawings to confirm that the work that the contractor is intending to do comports with the design and allows the contractor to coordinate how its work is going to be done and verify that the project can be built the way the designer intended it to be built. Again, common goal here. So submittals are a dialogue among the project participants to just make sure that there's no misunderstanding. Shop drawing is one type of a submittal. Material data sheets are another. Going back to my example where the owner wanted high-end millwork or high-end fixtures, the contractor, before sourcing the materials, before putting money out, is going to present material spec sheets to the designer to say, hey, you specified lantern style, exterior fixtures. I've got a supplier. Here's 3 different choices. Here's the price points. Tell me what you want me to use. Samples, whether it's flooring or millwork or windows. If you get samples, you can show them. We had a situation with tile where there was significant tile work being done in a building, and the subcontractor ordered all of the tile, $1 million worth of tile, and it was there ready to go. Then they used the tile and there was a change to the work and they needed additional tile as a result of the change. Well, that original tile was sourced, a year before. The suppliers in Italy, they're closed for a month in August, and we've got a substantial completion deadline and we're short a certain amount of tiles. We can't get them. Okay. So these are the kinds of things where you do maybe you're going to have to do a substitution. You're submitting a proposed alternate tile? Is it close enough? Does it, does it look the same? Is it in a different bathroom? Such, this was a dormitory building for a university. And, that what they ended up doing was using consistent tile over here. And then there was like one executive bathroom and they had to use a different tile. And that's the way they managed to do it. And this has to do with, there was a big delay in a dispute because we were waiting for the designer to approve this alternate tile. These submittals, as reflected in this example, there was a delay, there was a cost, the original tile wasn't available or wasn't available for long enough. One of the construction managers on the project, in an effort to find the same tile, started researching to find the same tile. Maybe somebody had some leftovers from another project, so they ended up spending hours and hours and hours contacting other customers of this supply house to see if anyone had leftover tile. You want to do all of this, whatever you can, save time, save money. Any questions? Go ahead.
Did they find the tile?
No, they had to, no, they didn't find the tile. They had to source a similar tile. It was slightly different shade. There are things you can do in that situation as a designer. You can use the alternate tile as sort of an accent tile, and that just saved me, 300 tiles. So now I'll have enough if I just put like an accent strip of tile around.
Jackie, one of the things we've seen as it pertains to scope is there'll be a clause that says any inconsistencies in the scope of work on the architectural drawings, the subcontractor is to use the higher level or the more expensive or the better, however they phrase it. And there are a lot of inconsistencies, unfortunately, where on one page it says to do this, but on another page it says to do that, and on a third page it says to do something completely different. So the architect missed it, the general contractor missed it, and now the sub is being held responsible for inaccurate drawings. And if there's nothing, if the clause says you do the higher of the three, you're stuck.
Well, that I think reflects the importance of the submittal. So what you do in that situation is you submit, or you do an RFI, request for information. You do a submission. You say, the contract's not clear. This is what I'm proposing to do. This is how it will or will not impact time and money, and get approval for it. And then that takes that.
Yeah. The issue is if, the architect missed it, the GC missed it, and the sub misses it. I mean, they usually say, well, you're the expert, you should have caught it. Well, we didn't even look at this section of blueprints because it's got nothing to do with us, but there is one small little piece with a cross section that shows something different. Now you're telling us we need to do that. So again, it all goes back to, it's that risk reward.
Exactly. I mean, in that situation, you would want to submit a change order and fight for it. Yeah. And just show how everybody else missed it and how it's different than what was spec'd to begin with.
Or just eat it because you're going to lose anyway.
Well, I think that's an important point we should touch on a little bit, because there's a certain amount of eating it that is incumbent on all participants. Somebody's got to take, and let me go back to what I said in the very beginning. First, the risk should go to the party that has control. If there's no one in control, it should go to the what did I say? The party that can bear the risk. And if there's no one else, then it's got to go back to the owner.
It's all about leverage and who has it and who doesn't have it. And, I think the message there is even, at every level down to the sub level, you've got to find the differentiating factor about you that makes you more valuable, where they don't just go to the next guy. Because even though you're doing the same thing, you're doing something somehow different, whether it's the service aspect or, fill in the blank. You have to differentiate yourself so that you gain some leverage. Otherwise, it's always going to get crammed down your throat.
And that's where we go back to the lowest responsible bidder. So if you have a reputation in the industry for doing careful, quality work, even if you come in a little higher than the next guy, but your reputation is such that that you're reliable, then you're going to get that job.
Yeah, where you're finding ways to add value, somehow creating dollars for, up the food chain because of however you differentiated yourself.
And using the submittal process is a good way of showing how you can add value.
And have a good lawyer.
Always.
Also,
I couldn't agree more with that.
I mean, honestly, all kidding aside, I've been in situations that where I'm like, listen, if I've got to call who's your attorney? And I say who it is, and they're like, oh, hold on a second, let's see if we can have a conversation. So it does.
We do, right, exactly. The same thing, we have to have a reputation in the community such that people know that, we're not going to take unreasonable positions, that we're going to be fair, but we're also going to be tough. I think it's across industries. I mean, don't you gentlemen have the same?
Yeah, I agree. I think that's important to know that you can, from our perspective, work with our clients within, obviously the laws that exist, but, be upfront about what's going on. So.
So we're getting close to running out of time, and I'm sort of really motivated to try to get to steps 9 and 10. We have a couple minutes left.
Go for it.
So let's go for slide number 9, review of construction activities. So I know no one in this room or on this call would ever do this, but I have had situations where owners relied on contractors to just get the work done with a limited amount of review and supervision. That can be a problem. And I always recommend to my clients who are not in the construction business that, in the construction world, when you're representing owners, there's a lot of one-offs where you have, a company building its new headquarters, or a business person, business startup building their facility. These are not owner developers where they're constantly building. They're doing one project of a lifetime and that's it. In that situation, I strongly recommend to our clients that they hire an owner's representative to be the owner's eyes and ears on the project, to go out and review not just the status of the work, but the quality of the work, et cetera, and just to be eyes and ears on the project.
I think those projects too are a slightly riskier for contractors and subcontractors because of the lack of sophistication of the owner and the expectations not necessarily potentially being properly aligned because of the lack of experience, which creates a higher risk profile.
Right, exactly. So, one way you can do it is staying very on top of your project meeting minutes, daily logs. Looking at these things gives an owner, without physically being on the site, a very good idea of what's going on, how the work is progressing, and whether and what issues are coming up. But I'll tell you, being physically present is an even better way to stay on top. And if you can't do it yourself because you're not there or you don't have the expertise to do so, hiring an owner's representative is the way to go. I'll give you an example. An investor, a real estate investor, wanted to buy a piece of property, build on it, and flip it as an investment. They bought a piece of property in a different state from where the owner, were located, and they thought that they could manage this process from another state by making bi-monthly visits to the site. Lo and behold, during that time, they came to learn that, some weird stuff can happen. One of the subcontractor's employees was living in the building shell. There was material stored on site, whether it's copper or, 2x4s, one walking away here and there, so not staying on very closely on top of construction activities can lead to any number of problems. You really have to be present, and you really have to know what's going on. And if you don't, then you need to hire somebody who does.
And being there like that helps you catch issues early on in a project, which then there could be a discussion, and that issue could be resolved before that small issue becomes a big issue and becomes much more costly.
We're in the process of doing that right now. We're tripling the size of our New York City space. We're close to a final deal in an iconic historical building, and it's going to be a complete build out of the space by the landlord. But we're going to have owner representation because A, I don't know exactly what I'm looking at. B, it's New York City. It's a whole nother animal in an iconic historic building, yet a whole nother animal. And, there's people out there that this is all they do is own a rep on projects just like that. And it's surprisingly a very low cost. It's not an expensive endeavor to have that representation and that set of eyes kind of looking out for your interests.
Yeah. It's always, penny wise and pound foolish.
Yeah.
There's a lot of owners out there who are very reluctant to add that additional element of cost. I can do it. I have a client right now who is somewhat experienced developer. But he's actually a medical doctor and retired from medicine and started developing real estate, sort of as a second career, something fun to do. And he's got a home office. He's got people on his staff, and he's looking to build this $75 million project. And there's some land use issues. There's access issues to the land. There's traffic control issues. And he's working with a contractor he knows very well and who comes highly recommended from very trusted advisors. But regardless, I said, doctor, this is not what you do for a living. And my suggestion is that, you have a very cooperative, wonderful relationship with this contractor. Let's not screw it up. Bring in a third-party owner's rep, and then that person can handle that sort of delicate interaction with the contractor, maintain relationships, ensure that the work is progressing the way it's supposed to. And, the key, catch it while it's still small. The last thing that any owner wants to do is terminate a contractor. The very last thing. I mean, you could do the worst thing in the world as a contractor, but if you're in the middle of a project and approaching completion, nobody's going to fire you because it just costs too much money to start over with somebody new, and it takes too much time. So the owner will try to work as, the situations where contractors are terminated, they're pretty extreme. The contractor abandoned the job. The work is of such poor quality that they're not passing inspections and can't achieve substantial completion. I mean, it's got to be pretty bad to terminate. So when you have, when you're staying on top of reviewing the construction activities, everybody knows what's going on at all times. Again, recipe for a successful construction project. We only have a couple minutes left. I'm going to do it. I'm getting to step 10. Step 10, periodic audits of contractor billing. And for contractors who are here in the room and on the call, please don't be offended. But there are contractors out there in the world who will take kickbacks from subs or suppliers, who will overbill and try to hide it within, a schedule of values, try to shift costs. I mentioned this before. It is a very common contractor strategy to bid low and sort of count on making up for your low bid with excessive change orders. And these are
Kickbacks.
and kickbacks. So by using the resources, again, if you don't have the resources in-house to do it, it's very easy. You guys, Austin, I mean, you know,
Yeah, it's a lot of what we did looking at how the contract is billed from the schedule of values and where they stand from a cost perspective. It was important too to understand, like you said, overbilling. Are they overbilled? Are they not overbilled? Are you underbilled?
right. You know, and contractors also, not only they also tend to front load on their schedule of values. And what I mean by that is a contractor will in terms of its progress of completion on the schedule of values will allocate a significant percentage of the funds coming in to the early work, the excavation, the demolition, excavation, site work. And, you know, you're a couple $1 million in, and then you get to the end of the project with the finish work, and there's not a lot of money left in the budget, and then that's going to cause the contractor to slow down and go work on another job because they need cash flow. So by auditing the billing, you can stay on top of that, make sure the cash flow is smooth. And it's incumbent on the owner to ensure that your contractor has a sustained cash flow, because that's what happens when the contractor run out of money. That's when they stop sending, you know, they go down to 4 guys instead of 20, you know, because now they're going to go put these other 16 guys on another job where they're going to get cash flow. If you can't do it in-house, hire Austin to do it. And these are the steps to a successful construction project.
Thanks, Jackie. Boris, thank you very much. Good presentation.
Thank you. Does anyone have any questions? I think it's very clear that we're going to have to come back and do another construction law forum and spend the whole time just talking about contracting.
I have one. I talk a lot.
I like that.
Yeah, some people do, some people don't. So I was in a situation, Todd knows about my situation. I had a very, I'll call it influential meeting with a very powerful developer last week. And I kind of, lack for better term, ate a lot. And with that, he said to me, I brought up our contract and how they input my specific bid into their contract. And he goes, I'm going to stop you right there. If you think that your contract has weight over mine, you're completely false. I have verbiage in that, and I'll show you if you want me to. Where my bid form was input as an exhibit to their contract. And he says, I have verbiage. I don't know the verbiage off the top of my head, but he's like, I have verbiage that basically disputes anything and supersedes anything that you had within your contract, your bid. So, you know, that's a powerhouse saying that to me, one. And two, how do you get around that? Even though they're in, so this is, and one, this is the only developer that actually inputs my bids into their actual contract. Because on my notes, I, you know, say this bid needs to be input as a rider to the contract. How do we get around that? If there is anything at all, they're most likely, in my opinion, not going to take that verbiage out that states they're, as Todd was saying, they have more language in there that supersedes a lot of the stuff that we say.
Right. So I'm guessing that the clause that you're referring to is you're right, it's typical. And it says in the event of a conflict among the documents, this is the order of precedence. And it says the construction contract controls, after that, the general conditions, after that, the design, and after that, the contractor's bid.
Sometimes it'll just say in the clause, this supersedes any and all other verbiage.
That's what it is. Yeah.
Yep.
Right, and any conflict between an exhibit and this agreement, the agreement governs.
Yes. So, and, Bill is a corporate lawyer, and this is a clause that it's not just construction contracts, it's all contracts contained. And to be honest with you, this precedence clause, it's required because otherwise it's confusing. There has to be a controlling document.
Right.
There has to be. So, how do you deal with it? Well, your bid, you have to be pretty comfortable with your bid. you have to really be careful with how you bid. And maybe you need to do some independent cost estimating to make sure that, you know, what your knowledge and experience is telling you is realistic in today's world. You know, maybe you've done this 100 times and you know it's going to cost you $100,000 for this material. Well, rather than just rely on your knowledge and experience, maybe you need to go out there and just check and confirm and double check and confirm.
And sometimes when you don't have the leverage, you know, you have to pick if there's one or two things that are really important to you or you're really concerned about, and you know you're not going to be able to ask for much, you kind of have to pick your one thing to say, hey, look, I can live with your contract in its entirety. I have one thing that's important to me that's a concern. Here it is. That's the change I'm requesting. You know, until you have the leverage, you have to try to pick your battles, knowing you're not going to get much. And if it's a reasonable fear or request that, and they can relate to it, sometimes you'll get that change if it's reasonable.
Well, and it goes back to them making a business decision, whether you're comfortable or not to live with that verbiage or not. Can you get the job done? Yes. Are you comfortable? Yes. Then you sign it. If the answer is no, then you have to move on.
Yeah. So I mean, that's the answer to your question.
Yep.
You gotta know who you're dealing with.
Right.
I mean,
Relationships
there are people
matter,
that,
too.
I mean, if someone flat out says, I don't care about you at all. I don't care what happens to you. I'm out.
Absolutely. And there are owners out there that say, it's all on you, and I'm going to stick it to you every chance I can get. Well, that's not an owner you want to work with. You know, listen, let's say you're in a situation where you don't have work in the pipeline and you're like, oh my God, I got to take this job because I have nothing else. If you get that spidey sense that's how it's going to go, you are way better off doing nothing than taking on a job that's going to end up with disputes.
Yeah, there's no doubt about that. I mean, I can think back throughout my career and you know, especially at the time of the Great Recession, I had some clients who were desperate for work and made deals that, you know, in hindsight, they wished, you know, the greatest deal ever would have been that one they didn't make, because it, you know, it raveled, you know, a lot of people got unraveled by making those desperate deals during times when business wasn't good.
Have confidence in yourself. You know, hold yourself to your own standards. Don't reduce your standards. Well, thanks everyone.
Thank you.
Really,
Thank you.
it was a great discussion.
Thanks
You
to
know,
all our listeners
yeah,
online.
we always prefer when it turns into a dialogue. It's more, you know, it's fun. Thanks everyone. My email should be on there. If you have any questions or need anything, just shout out.
Will do. Thank you.